Welcome to this mock session of the International Court of Justice. My name is Justice Robert Torres, and I'll be serving as co-president of the court along with Justice Millicent O'Donnell. We are joined by fellow justices Nicola Payne, Michelle Weeks, and Michael Wilson. You may proceed.
So my question is, what to you is the severity of this 4-degree world that you've described in your materials? What difference does it make if the Earth heats up to 4 degrees? What would that look like? You've asked this court to consider applying the criminal culpability to behavior that you described as ecocide. Why is there now a sufficient threat, a seriousness of injury that would justify criminalizing the behavior that would lead us to a 4-degree world?
Je pense que c'est important de parler de notions de crise et de danger actuellement, car malgré toutes les recommandations qu'il y a eu depuis des dizaines d'années, les pays n'ont peut-être pas pris encore la mesure de l'importance de ce qu'il se passe actuellement au niveau du changement climatique. Et en tant que jeune Française et en tant que jeune citoyenne du monde actuel, ça nous fait peur à nous parce que c'est notre avenir qui est en jeu vis-à-vis de ces situations-là. Par exemple, en Nouvelle-Aquitaine, on a été énormément touchés par tous ces changements climatiques. On peut le constater, nous, sur nos côtes atlantiques, avec le recul de la terre, la mer qui attaque nos côtes, etc. Et on le ressent visuellement en tant que citoyen. Et c'est pour ça que ça devient un danger et une réelle crise, car maintenant, c'est effectif. Ce n'est plus juste une expectation, c'est imminent et ce sont des choses qui se passent actuellement. Les effets, nous les voyons maintenant. Et nous avons besoin de réelles mesures mises en place par nos États, par la communauté internationale et des mesures effectives, pas seulement des recommendations or not only recommendations, vraiment real measures that are imperatives. Concernant l'écocide, dans ma présentation, je l'ai amené comme un dernier recours, car on préférerait que la communauté internationale et aussi clairement notre pays soit ait pris conscience de la chose et qu'il n'ait pas besoin d'aller jusqu'à un aspect criminel pour mettre les choses en œuvre. Cependant, étant donné que toutes ces recommandations ont déjà été faites pendant des années et que maintenant les impacts sur l'environnement sont de plus en plus importants, concernant l'écocide, je pense que ça pourrait être une solution de dernier recours et une solution efficace dans la mesure où, sous la contrainte en général, les personnes, que ce soit les politiques, les citoyens, les États, réagissent mieux. Et ça pourrait être une solution de dernier recours, mais je crois encore que nous sommes assez investis et protecteurs de notre planète pour ne pas arriver à ce stade-là et pour que nous prenions conscience maintenant qu'il faut réagir tout de suite et dans l'immédiat.
And you seem to be suggesting that this duty to act needs to take place even at the level of international bodies that are applying the rule of law, such as the International Court of Justice, or I assume you're also referring to the International Criminal Court. But if it is your position, and I think you have articulated it well, why is there an extra obligation on the part of this court to act because of the injury to children that would result from massive deforestation?
We realized that there's a very high threshold and a very high legal standing for children. So they can both, they can go to court and have higher protection and be heard, but they also have stronger rights that they can claim. So this is why we can see regionally with the Urgenda Foundation case that I mentioned in my pleading, but also the Philippine case that was in the early 2000s or late 90s, if I remember correctly. And there's a growing regional courts attempt in recognizing environmental harm and how it affects children's rights, but also just generally human rights. And that's why I believe it will come to the international courts at some point in the next few years, because it cannot be avoided with this general regional consensus that is growing in jurisprudence.
The reason why we're addressing this court also is because regarding the right to fulfill human rights, one of the measures that states have to take is also to pass legislation accordingly. And since deforestation is a scientific proven cause of climate change, which is affecting all human beings, but children and vulnerable communities in particular, we think that this court should make states take those appropriate measures to protect forests in order to protect human rights at the same time.
Just a quick one. We noticed that there are many treaties, many legal frameworks to protect the environment at the national level, regional level, and then the international level. Why is it that you are bringing the issues to the International Court of Justice? Have you tried to deal with the issues at the national level?
I think sometimes when nationally courts are a bit slow in taking difficult or drastic decisions, I think it's also important to go to, for example, other regional courts or international courts and push them to legislate and judge further. Because, for example, if I, as a French citizen, go to the European Court of Human Rights, I can make France legislate new laws if the European Court of Human Rights decides that France has infringed on certain environmental rights. Then France has to work on those rights and has to promote them and ensure that they're respected. So I think there is 3 levels that, of course, must be addressed: national, regional, and international. But I don't think one excludes the other. I think they should all work together because it's a very difficult crisis. It's an urgent one, and we cannot afford to wait or lose time. And we can just, try all the different solutions we have, if that makes sense.
We are aware that Kenya ratified the Kyoto Protocol in 2005 and has shown commitment in contributing to continental and regional climate change initiatives for the benefit of the present and future generations by supporting the UNFCCC. Now, we are also aware that on May 2020, Kenya declared that through reforestation project, they will plant 1.8 billion trees by the year 2022 in order to preserve biodiversity. My question is this enough to protect the forests for the present and future generations?
Your Excellency, as a Kenyan, this question is dear to my heart as it directly affects my country. Your Excellency, my answer to this question is no, it is not enough. What this measure is doing is merely treating a symptom of a problem and not the disease itself. The disease in this case being deforestation in Kenya. Your Excellency, the main problems that cause deforestation in Kenya include land grabbing of forests such as the Mau forest, the illegal conversion of forests into land for agriculture and settlement, forest fires, and corruption that enables all the above. Your Excellency, until these issues are dealt with, planting 1.8 billion trees will only mitigate the problem and not end it entirely.
Broadly, assuming the ICJ can make such a broad principle declaration, will it really matter? Can it be given effect? And would it be better to, in fact, strengthen existing sectors? So that's the first question, and then I have another one after that. Thank you.
Thank you for your question, Your Excellency. The requests that I have made under New Zealand's submission relating to international trade are intended to aid existing international agreements in their interpretation and specifically in their prioritisation of the assessment between trade and the environment. Because we currently do have international agreements that deal with forests and trade, However, at this stage, the balance between them does lean towards prioritising trade. The declarations that we have requested from the court would help to shift states' assessment of this balance so that we recognise the fact that while international trade is crucial for the health of the international system, we do require a healthy environment for that to continue, and that the current state of international trade doesn't align with continuing to give our future generations a high quality of life. I acknowledge what you're saying about the domestic law being absolutely crucial as well, and that is very true. We hope that the submissions that we've made around the declarations will encourage states to apply that within their domestic law. Within the international trade law, there is obviously a lot of domestic law that reflects that. So therefore, if the policy that states are making at the international level do value the environment to a greater extent, this should also be reflected in the domestic law.
And the impact of climate change. So my question is, how do we reconcile traditional knowledge and of the traditional communities to help in conservation and management of diversity for the present and future generations? My second question is on the balance between sovereignty and transboundary harm. How can we strike that balance in the climate change context to protect the forests, the present and future generations? Then the next question is on what level of harm should trigger the obligation?
Certainly, traditional people and local communities are the guardians of biodiversity. And this has to be increasingly acknowledged first and foremost by our environmental policies that are currently being discussed. We know that in an international scenario, the decade for biodiversity action is coming to an end. And the Starking report that has been published a couple of months ago showed that none of the 20 IC biodiversity targets have been achieved and will be achieved under the current reporting period. And traditional knowledge is a big component of biodiversity, not only biodiversity in general, but also biodiversity for food and agriculture. And in terms of our perspective that we discussed in our memorial, from an ecological approach to international environmental law, we do really understand that we are all part of nature. And this is a vision that is shared by many indigenous people in Latin America, for instance. Here, many constitutions already included rights of nature. And this is a reflection of this cosmovision. We can call it in Spanish as buen vivir of the traditional people. And so, in general, it's really important that we acknowledge first this different perspective of traditional knowledge in terms of biodiversity conservation, restoration, and sustainable use. In terms of law, it is really important to acknowledge first the rights of indigenous people, especially the rights to prior informed consent, the rights. For instance, in Brazil, we have many land disputes of traditional territories, which is something that also has to be addressed by our national courts, for instance. And it's something that has to be brought to the attention of legal general scholarship, which is really important.
Do you believe the UNFCCC, if a statement such as you were seeking is made by the ICJ, can that in any way deal with private actors? Of course, I'm thinking of large emitters of greenhouse gases. Does the UNFCCC provide a mechanism in that regard?
Your Excellency, the UNFCCC, being a framework convention, provides a way for the greenhouse gas, provides a provision for the greenhouse gas emissions to be reduced. However, there are also other treaties like the Paris Convention that specifically deals with the current problem, Your Excellency.
Thank you very much for those responses. Could I now ask Ms. Morin, my apologies for my pronunciation, some questions. The matter that I was quite interested in that you didn't have time to deal with is really the extent to which domestic law can influence international law. And in your section on human rights, you do refer to the United Nations Human Rights Framework. which is unusual, and allowing non-state actors such as civil society, of course, to make complaints, etc. But you also refer to a number of domestic law cases, which are grounded, of course, in domestic law as well as in the agenda case, the European Human Rights Framework. To what extent do you think international law is influenced or can be influenced by domestic practice?
For that question, Your Excellency, it can be observed that there has been state practice in bringing states and private actors accountable or be held liable in domestic courts. And this can be vital or crucial in influencing international law. For example, in the case of the Philippines, we have Greenpeace versus Exxon, and this is an ongoing case. We have 12,000 petitioners, Filipino petitioners, and these petitioners invoke the UN Guiding Principles on Business and Human Rights and the Maastricht Principles. These principles focus on the role of states in regulating the conduct of businesses. Particularly, these businesses primarily are mandated in not interfering with our human rights. And since the right to live in a healthy environment is a well-recognized human rights, accordingly, businesses should desist or cease from committing actions that would threaten our right to life. So in this case, Your Excellency, given the pattern that in the domestic level, citizens are now bringing the states themselves in cases where the states would fail to regulate the conduct of businesses or private actors, it is possible that it can influence international law.
So as I understand it, you're saying if enough countries or the citizens in enough countries prosecute their governments, if they're able to, that will develop sufficient customary behaviour, potentially, that may lead to a change in international law.
Not necessarily, Your Excellency. Not only the actions made by the citizens as well, but it is well recognized in several climate change related conventions that climate change is a common concern of humankind. And together with this plus state practice, it can influence international law itself in the context of climate change, more especially in strengthening or in enforcing the obligations of states and businesses, Your Excellency.
Thank you. I have no more questions, Mr. President.
My question involves the legal concepts of dualism and monism. As agent for the African Union, I am just wondering, in preparing your submissions, did you detect a difference in the treatment of states' obligations under international law to protect forests, depending on whether the legal system is based on dualism or monism? And if there are differences, what are their differences in treatment? And what measures would you recommend to redress any differences in order to ensure that all states comply with their international obligations?
Your Excellency, yes, I did. The main differences I saw were that in a monist state, as soon as a treaty has been ratified, it forms part of the legal system of that country and can be applied directly to that country. However, in a dualist state, in order for international law to be applicable in that country, legislation must be passed to give effect to international law. Your Excellency, as you could see, this poses a challenge in dualist states as they may ratify a treaty and fail to pass legislation to give effect to the treaty. Thus, the measures I would recommend include 1, providing an economic incentive to encourage dualist states to pass legislation that would give effect to international law in the protection of forests. Your Excellency, as a representative of the African Union, I would remind the court that many African countries are still developing. Thus, economic incentives would encourage dualist African states to pass legislation in the protection of forests that is in line with international law, especially if they are in line with their development efforts. The second measure I would submit before the court is utilizing the principle of common but differentiated responsibilities. Your Excellency, many African countries still need to exploit their natural resources, such as forests, to provide for their citizens. However, this doesn't mean that they exploit all natural resources to the point of depletion. International law that is formulated should bear in mind that developing countries cannot compete at the same level as developed countries. and thus some allowances should be made in a treaty. For example, a provision could be made where developing countries can still carry out their economic activities but slowly cut down on practices that are harmful to the environment over a given period of time. This would encourage dualist states to pass legislation to this effect.
One of the requests that you've made to the court is that you're calling for action on loss and damage to help vulnerable countries, and you want to look for stringent amendments to further strengthen the Warsaw International Mechanism for Loss and Damage. I assume that you believe that compensation should be paid to displaced refugees, either displaced by extreme weather or uninhabitable land, and maybe that compensation includes relocation costs as well as compensation costs for loss of their homelands. But how do you suggest there would be a fair and rational manner to allocate that responsibility amongst states?
Your Excellency, regarding the amount for the compensation, it has been recognized there is a difficulty in citing the causation, the causal link between greenhouse gas emissions and the climate change itself. So based on several domestic jurisprudence, such as in the case of Leluya versus RWE, the domestic court took into consideration the amount or greenhouse gases by the private entity itself. So in this case, in the international level, since there has been a widely available data on the greenhouse gas based on state inventories, this can serve as a basis for the amount of the said compensation that will greatly help the small island states, Your Excellency.
You advocate for an ecosystem-based approach that recognizes the interconnected nature of the forest. If we were going to adopt that in our advisory opinion, what would be the guiding principles that we would send to states to provide some clarity to what their obligations are under this interconnected nature of the forest principle that you advocate for?
Thank you for your question, Mr. President. This would be an issue that would need to have consideration for specific ecosystems and their needs, but it would require states to acknowledge and make allowances for the health of ecosystems before undertaking major trade projects. I would say that, for example, a specific requirement may be the need to acknowledge specific species that may be disrupted. For example, with forests, you need to look at the insects and birds and ensuring that they have alternative opportunities for example, like breeding and living. If, for example, one patch of forest is being destroyed, that there are alternatives and that the restoration gives consideration for multiple species and not just the restoration of a specific plant, for example, the forest, the timber product that is being utilized.
The court will take the matter under advisement and will now stand adjourned.